and I didn't want to die that night. Somebody came at my door trying to kill me,
And I
and
didn't.
I ended up at the hospital. I called the cops. She has the phone record that I called the cops asking for help. I ended up at the hotel. I did everything wrong, yes, but I was just trying to save my life that night. I didn't want to die that day. I was just.
Right.
I appreciate your time.
All right, you're welcome, and thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing?
All right, guys. Today we are going to witness a courtroom moment that jumps straight into raw fear and desperation. The defendant opens by insisting someone tried to kill him that night, recounting panic, confusion, and rushing from a hospital to a hotel, just trying to survive. It's an emotional start that sets the tone for everything that follows in this complicated hearing.
Hello, how's it going?
It'll be better.
All right, so my understanding, you want to represent yourself? All right, you're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so.
Here, the judge calmly but firmly lays out the reality of self-representation. She explains that being your own attorney isn't just talking, but navigating rules, objections, and legal traps without anyone stepping in to save you. She warns that once a trial is set, it moves forward with no special treatment, highlighting how risky this choice really is.
But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there.
The defendant shifts into sovereign citizen language, rejecting the legal identity on the paperwork and insisting he is only the flesh and breathing man. The judge tries repeatedly to pin down a simple confirmation of who he is, but every answer circles back to his unusual definitions, signaling this hearing is about to get much more complicated.
I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment.
The judge hands him the indictment and explains that the court cannot teach him how to interpret charges. She uses a sharp analogy, attempting surgery alone in the desert without a doctor, then asking for guidance mid-operation. It's her way of showing that representing yourself means no one will guide you through the legal dangers ahead.
You're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness. You need surgery and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney.
As the judge orders an attorney to come down, the defendant continues repeating that he does not understand. He then tries entering his own constitutional declarations onto the record, insisting the court failed to inform him properly. The tension grows as his statements clash with the judge's efforts to keep the hearing grounded.
After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right. So let the record of the court show that I, Hector Casanova
Just 1
Jr.
second.
We're
just one stop. All right. We're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action. Furthermore,
let me
let
stop
the record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
The hearing escalates when he asks whether his charges fall under civil or criminal law, then demands to know if the court is operating under common law or military tribunal. The judge keeps redirecting, clarifying it's a felony district court. His questions, rooted in sovereign citizen ideology, push the courtroom into deeper frustration.
I believe so.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment In the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from Managed Assigned Counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
The judge finally shuts down the jurisdiction debate and orders him to sit. Standby counsel is assigned, yet he continues asserting he's appearing under threat, duress, and coercion. When the judge asks who forced him to come, he claims the county will kidnap him if he didn't show, revealing the depth of his distrust in the system.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under. Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
All right, I'm going
admiralty or military
to counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for Managed Assigned Counsel, period. That's it. So have a seat. Managed Assigned Counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat. Thank you.
We have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's going to consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay. All right. And so you'll be appointed as standby
Yes.
counsel then.
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So,
All right. We're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right. So, Mr. Casanova, Mr. Bonk is going to be your standby counsel.
The
And
judge resets the case, explaining the discovery process, upcoming plea deadlines, and strict expectations about showing up. She makes it clear that only hospitalization excuses an absence. The defendant asks about rescheduling, and the judge emphasizes the seriousness of court obligations, ending this segment with procedural clarity despite earlier chaos.
and that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record.
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer, come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date, and then you'll sign it. Mr. Bach will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome, and thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing? Does it
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator, and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
All right, Judge, he's on his way up. For your edification, this was a plea that we entered in front of Judge Angelini for 10 deferred.
Oh, no, I remember.
Okay, well, I'm just going to fill you in on what's going on then today.
All right, what's happening today?
So I asked the DA if he would be willing to consider the 10 deferred. He said, let me think about it. We did enter the plea fully and officially on the 4 silent. Mr. Hernandez then tells me he wants me to put in a motion to dismiss for prejudice, and I told him there is no such thing because, you know, judges bust plea bargains all the time. That doesn't give you a right to dismiss. And so then he says, well, he wants a jury trial. And I said, well, we have entered the plea on the 4 silent, so the judge may or may not allow you to withdraw your plea, and then that's what he wants to speak to you about.
All right. All right, we can go on the record.
Yes, ma'am. I just didn't understand what I was signing. And
Excuse
She
me.
hasn't
I'm
started
sorry.
yet.
I'm sorry.
All right, and let me stop you right there. All this thing where people say they don't understand what they were signing, based upon what is the information that I've received, that first it was 10 years deferred and the judge denied it, and then it came back to a silent offer. Yeah, everybody understood. Court is calling 2023 CR 10221, State of Texas versus Joe Hernandez. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
For the defense?
Suzanne Kramer.
All right, and are you Mr. Hernandez?
Yes, ma'am.
All right, a plea was entered in this case on, let me see what date is stamped on here, on April 22nd, 2024. According to the plea bargain agreement, punishments to be assessed at 4 years in the prison. There's a $1,500 fine, and the state is silent on the defendant's application. All right, with regards to the plea bargain agreement, the court, of course, does not have the PSI because we're coming back. Can someone tell me what his criminal history is?
Judge, I don't have a file on that.
Basically, I could be off on this, but my memory is some minor misdemeanors and no felony convictions.
So, counsel, do you wish to have a PSI done, or do you wish the court to make its ruling?
Honestly, Judge, based on his criminal history, and of course, you don't have the benefit of the interview with him, but Mr. Delgado and Escobar and I can fill you in on part of the, I think it was part of this plea bargain too, was evaluation for Mick. There are definitely some mental health issues going on. You can tell by reading the report, but you do not have the benefit of having that in front of you. But I do feel confident, of course, it's up to him to go forward today.
All right. So I am reading the police report, and based upon the police report that I read that are in the stipulation, there is documentation of bizarre behavior. And I don't know, based upon the police report, if that bizarre behavior was drug induced or if there's some sort of mental health issues.
Which is why I think we had dual, right, with Mick, or was it just Mick?
I'm making that, yes, that was awesome.
I mean, based on my time, and certainly I'm not an expert in any way, but I would tend to think it might have been both, but definitely some mental health issues.
All right, Mr. Hernandez, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Joe Hernandez.
All right, so Mr. Hernandez, have you ever been diagnosed with any type of mental health issues?
No, ma'am.
All right. Not even in your childhood?
No, ma'am.
Drug use?
No, ma'am.
You're telling me you never used any drugs?
No. I'm an alcoholic, yes. I drink, but that's it.
All right, so
The next defendant steps in with confusion about his plea, claiming he didn't understand what he signed. The judge pushes back, reviewing the offer and questioning his mental health history. He recounts believing someone tried to kill him, insisting he only acted out of fear. When offered options, he rejects the plea and chooses a jury trial, locking in his path forward. Like the video, subscribe to the channel, and we'll see you in the next video.
in the stipulation, they're saying that you were exhibiting bizarre behavior.
Somebody was trying to take my life that night, and I was just trying to save my life. I was asking for help. And I didn't want to die that night. Somebody came at my door trying to kill me.
And I didn't.
And I ended up at the hospital. I called the cops. She has the phone record that I called the cops asking for help. I ended up at the hotel. I did everything wrong, yes. But I was just trying to save my life that night. I didn't want to die that night. I was just, I didn't want somebody to take my life for no reason. That's the God's honest truth. And I'm here fighting this. I don't have mental issues.
Oh, I mean, if you want a jury trial, we'll give you a jury trial.
I'm 34 years old.
No, if you want a jury trial, you can have a jury trial. That's your question.
Or you can request the judge to give you deferred, and then that way you know that you know what the end result's going to be.
I have a right to face my accuser, Your Honor.
No, here's the thing. And this is what I don't think people understand. We can go off the record. Everybody thinks that they can be an attorney without a license. They want to throw around magic words like Jack and the Beanstalk. Oh, let me throw right to accuser, right to confront. Let me throw, I want a dismissal. The question is, do you want a jury trial? Yes or no? And let me explain something to you. If you say you want a jury trial, this train is going to a jury trial. This train is not at the last minute. Oh, I see witnesses walking in the door, so therefore I'm deciding to enter a plea bargain agreement. If you want a jury trial, court will give you a jury trial. You will get a quick, fast jury trial. So you want to discuss that with your attorney? You can. You all want to discuss that?
I'm good with the jury trial.
Do you want to discuss that with your client?
I think based on my conversation with him earlier this morning that he is, because of what happened the other day, it just took him off of pleading and he wants his jury trial.
All right. We're coming back on June 3rd.
Thank you, Judge.
And you will have your jury trial. And your plea deadline date has expired.
Thank you, Judge.
You're welcome.
May I approach, Your Honor?
Just one moment.
Off the record?
Yes.
I'm going to the new Plaza Club on Weston to find out. It's supposed to open up. I'm going to find out what the lunches are about. I understand that you love the chop house.
Yes.
I don't think they have it. I'm going to find out and I'll report back.
Yes. Do away with their chops out.
Because the world changes, Judge.
Yeah.
Yeah, you know?
Yeah.
Okay, I'll probably text you.
All
Let
right.
you know what's
All right. Thank you.
Okay, thank you, Your Honor.